Commissioner Fielder, can you hear me? This is Patricia. Commissioner O'Donnell, this is Patricia. Can you hear me?
Yes, I can. Can you hear me?
We can, thank you.
Wonderful, thank you.
Commissioner Fielder, can you hear me?
Yes, this is Commissioner Fielder. I can hear you.
Thank you.
Okay. Good morning, everybody. Good morning, everybody.
Morning.
Thank you. That's better. The time is now 9:31 a.m. I will call this meeting to orders. Today's date is June 14th, 2022. This is the time and place for our regularly scheduled business meeting. Would the other commissioners please join me in reciting the Pledge of Allegiance, especially on this Flag Day, I believe.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, commissioners. I would note for the record that myself and Vice President Johnson are present in the Bollinger Room this morning. Commissioners Fielder and O'Donnell are present via Zoom. Commissioner Pinocci is excused. He's at a NARUC conference, so we do have quorum this morning. It's time and place for public comment. Are there any public commenters in the room? Seeing none, are there any public commenters online? Seeing none. Let's move into our action items. But before we do that, Mr. Reed, I think we have a special guest in the room this morning. Would you like to introduce him? Val, would you like to move council table?
Certainly, Mr. President, Mr. Vice President, Commissioners, I'd like to introduce Valen Anthos, who has been our intern working remotely from the University of Montana since the turn of the year. He's done yeoman's work and will be leaving us at the end of June. And so we invited him over to see how the magic happens, as it were.
What? You got to answer some questions now. What year in school are you in? Well, that's great. And where are you from originally? We talked about this morning. Indeed. And what area of law would you like to go into? Well, very good. Well, we're very pleased that we had your services for the last few months and you did a yeoman's job for us. And so we appreciate it. And we encourage you to stay in touch. All right. Thanks, Valen. All right. We do have one change to the agenda that I will announce that we are deferring work session item number 3. This was docket number 2021.09.118, which is the purple rulemaking. We will defer that to a later meeting. Back to action items. Action item number 1 is approval of the commission minutes for the week of May 31st, 2022. Is there a motion, Vice President Johnson?
Thank you, Mr. President. Move we approve the minutes as distributed.
I will second. Is there discussion, changes to the commission minutes for the week of May 31st? Seeing none, all those in favor of the Vice President's motion to adopt the minutes for the week of May 31, 2022, signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries. Minutes are approved. All right, let's move into our work session. Work session item number 1 is docket 2020.03.033. This is commission initiated Montana Energy Impact Assistance Act rulemaking. We're here to consider a draft notice of adoption. Mr. Hamilton.
Thank you, Mr. Chairman and Commissioners. Before you in your meeting materials is a copy of the draft notice of adoption for the Montana Energy Impact Assistance Act. This was a law that was passed back in 2019, I believe it was, that created a process for securitizing the retirement of utility assets and the replacement of utility assets. As you're aware, we've been through an initial notice of proposed rulemaking, a public hearing, an amended notice of proposed rulemaking that incorporated some changes to address supply cost tracking mechanisms and the minimum filing requirements for those mechanisms. We are now at the stage where we can adopt the rule if the commission is so inclined. We have received a number of both oral and written comments. Those comments are summarized in the notice of adoption as comments 1 through 4. If the commission has any questions about those comments or about the final state of the rule, I'd be happy to address them. But at this point, staff's recommendation is to approve the notice of adoption and authorize staff to make any edits that may be required by the Secretary of State's office to publish this in the Administrative Register.
Very good, Mr. Hamilton. I will move to approve the draft notice of adoption and authorize you or other staff to transmit the notice to the Secretary of State with non-substantive edits. Is there a second?
Second the motion, Mr. President.
The motion's been seconded. Discussion. Mr. Hamilton, I know that Representative Heyman is the sponsor of the bill from which this rulemaking is originating. Is that correct?
That is correct, Mr. President.
And have we touched base with Representative Heyman about this notice of adoption?
Indeed, we have, Mr. President. She is supportive of this notice of adoption.
All right. Thank you for checking that box, Mr. Hamilton. Any other discussion? Seeing none, all those in favor of my motion signify by saying aye.
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 All those opposed, same sign. Seeing none, motion carries unanimously. Thank you, Mr. Hamilton. All right, let's move to work session item number 2. This is docket 2021.07.098 Northwestern Energy. This is the unreflected gas cost account balance and projected gas costs and gas transportation adjustment clause balance true up to act on an interim order. Mr. Fink.
Thank you, Chairman and Commissioners. As you say, this application with Northwestern Energy was filed on May 31st, 2022. Northwestern proposes to decrease its natural gas supply rates from the current 0.665332 per therm to 0.559132 per therm. This includes an under collection balance of $5,150,156 of the total unreflected deferred gas cost for the 12-month period ending June 30th, 2022. Northwestern Energy is also proposing to include in its rate an under collection of $473,777 for the adjustment of the gas transportation adjustment clause. The difference between the rate effective June 1st, 2022 and the rate proposed to take effect July 1st, 2022 is a decrease for a typical residential customer using 100 therms per month of $10.76 or $129.12 per year, which amounts to a 9.45% decrease of the total annual bill. Again, this is an interim order and staff recommends approval. Thank you.
Thank you, Mr. Fink. Vice President Johnson.
Thank you, Mr. President. Mr. President, I move that we approve the interim order as presented by staff in docket 2021.07.098.
All right, I will second. Discussion, questions? Discussion, questions? All right, seeing none, all those in favor of Vice President Johnson's motion signify by saying aye.
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 All those opposed, same sign. Seeing none, motion carries unanimously. All right, as noted, agenda item number 3, which is docket 2021.09.118, purple rulemaking has been deferred. So let's move to work session item number 4. This is docket 2021.12.134, Caithness Beaver Creek LLC. Did we lose signal, Patricia? Okay. This is Caithness Beaver Creek LLC. CBC's petition to set terms and conditions of a power purchase agreement to consider a draft final order. Are we still broadcasting? Okay. Okay, ours is showing no signal. Mr. Hamilton, go ahead.
All right, thank you, Mr. President and commissioners. Again, this particular work session involves a lot of supporting materials. Apologies for the length of the reading assignment for this week, but it is an important docket. As you are all aware, this is another QF petition from Caithness Beaver Creek. This is the third version of the Caithness Beaver Creek petitions that the commission has considered. It concerns two hybrid projects that would be developed by Caithness Beaver Creek, combining wind generation and a battery resource. The commission held a hearing in this matter, and we are now at the stage following some post-hearing proposed orders and a brief from Caithness Beaver Creek and the Montana Consumer Council to issue a final decision in this matter. In your meeting materials should be two staff memoranda, one dated June 10th, which outlines in an executive summary the disposition of each of the key issues developed in this case, and then a June 13th staff memorandum, which details some substantive revisions that staff has identified since the circulation of the draft final order. So with the commission's indulgence, I'll just proceed through the executive summary on the June 10th memorandum. If at any time any commissioner has a question about the resolution of an issue, I'd be happy to answer those questions. Feel free to interrupt me. I think that in general, I will leave the analysis to the draft final order, since to run through those in great depth would require multiple hours of the commission's time, which I don't think is necessary at this point, but do correct me if you feel differently. So we'll start right off the top here with Roman numeral number 1, which is the legally enforceable obligation. The draft final order disposes of this issue by granting CBC their requested LEO date of November 17th, 2021. Very briefly, that is based on an interpretation of FERC's Order 872, which established a new standard, a new way of looking at the formation of an LEO. Under Roman numeral 2, the resources that will be included in the portfolio, the draft final order includes certain QF resources that were disputed. Those include Trident, Broadview, Meadowlark, and Upland Dillon. Applying the same LEO rule that was developed in Order 872 to those projects, the draft final order concludes that it is reasonable for Northwestern to include those projects in its resource planning. For the Northwestern owned or RFP resources, the draft final order also includes the Laurel, PowerX, and Beartooth battery, as those projects have made substantial progress towards development. Excluded from the resource portfolio are the Heartland Agreement, which was formed after the LEO date of CBC, and the Open Range QF projects, very small QF projects, but ones that have made progress away from development. They have ceded their LGIA. Moving on to battery dispatch control, the draft final order leaves control of that battery under CBC. That is based on an interpretation of FERC Order 69 and the arguments raised by CBC, interpreting that order to say that if the QF is so inclined, it can give dispatch control to a utility to increase its value to the utility, but it is not required to do so. So in this case, CBC has declined, and as a result, they will retain dispatch control over their own battery. Roman numeral 4 concerns the avoided cost of energy, and this issue has, as you're aware, a number of sub-issues. First is the methodology for calculating the avoided cost of energy. In the draft final order, the marginal cost to serve load method, which was proposed by Northwestern, is applied with separate heavy load and light load hour pricing. I should note at this point, based on the June 13th staff memorandum, there is a correction in this section of the draft final order. The avoided cost of energy methodology, paragraph 58, incorrectly represented what condition 2 hours price should be. So the June 13th memo corrects paragraph 58, or describes the correction in paragraph 58 to clarify the nature of condition 2 pricing. Letter B, under the avoided cost of energy, concerns the market forward period. In the past, the commission has adopted both 2 years and 4 years of market forwards. In this case, the the draft final order recommends a 2-year market forward period based on the record evidence and the testimony of CBC's witness. I should note as well, there was a correction in this section of the draft final order, which is detailed in the June 13th memo that describes the commission's resolution of the selection of trading days. This is an issue that the commission previously decided in CBC 2, the last CBC docket, to use 15 trading days from 2 consecutive periods to average the market information and thereby remove any short-term volatility or an incentive to cherry pick dates that would be used as the starting point for market forwards. This was just simply an omission from the original draft final order. CBC, as far as we can tell, also did not address this particular question in its post-hearing brief. So this new paragraph, a new paragraph 84, would answer the question and resolve the issue. The paragraphs that follow then in the final order will be renumbered. This isn't a replacement to paragraph 84. It is a new paragraph 84 that will stick in at that point in the draft final order. Next up under the avoided cost of energy is the market price forecast. The draft final order adopts Northwestern's market price forecast, which is that Ascend proprietary model, which will be used after the forward market period. There's an extensive discussion of this in the draft order, so I won't get into all of it, but the long and short of it is that Northwestern's market price forecast falls closer within the pack of other third-party independent non-biased forecasts, whereas CBC's forecast would take their final price of energy substantially higher than all other forecasts in the record. Letter D discusses the market basis differential. On this issue, the draft final order adopts Northwestern's proposed market basis differential to recognize the price difference between Mid-Columbia and the generator bus here in Montana. Issue E under the avoided cost of energy is the avoided cost of carbon, and applying the legislature's directive and new statute that amended mini PURPA says that the commission cannot use or factor in the cost of an externality that is not represented in existing regulation or law. Based on the record evidence here, there's no existing regulation or law that would impose a cost of carbon, and therefore there is no avoided cost of carbon to be reflected in this avoided cost of energy rate. Moving on then to part 5, the avoided cost of capacity, 3 sub-issues here as well. The first is the avoided resource, which in this case is an aero unit, an aeroderivative proxy unit, rather than CBC's proposed RICE unit or Laurel generating facility as the proxy. And this is based largely on the testimony of Mr. Grant, the representative from CBC, who identified the aero unit as one acceptable proxy capacity resource if the commission also adopted the inflation rates associated with that resource. Talk more about the inflation rates in a moment, but at this point, because of the apparent agreement among the parties, this includes Northwestern and MCC, that an aero unit is a reasonable proxy, the draft final order employs the aero unit as the proxy. Letter B under the avoided cost of capacity concerns the hybrid capacity contribution. In this case, the choice was between Northwestern's ELCC model and the SPP methodology offered by CBC, because SPP has evidently acknowledged that their model is not designed for hybrid resources, and they will in fact be moving towards ELCC for hybrid resources in the future. The draft final order adopts Northwestern's proposed ELCC model. Now, finally, under the avoided cost of capacity is the question of the inflation rates. We received 2 different sets of proposed inflation rates from Northwestern Energy and from CBC. CBC proposed to use the Mortenson Construction Index, which they represent is more closely related to the costs associated with developing a new generation facility than the CPI, the Consumer Price Index offered by Northwestern. And because the Mortenson Construction Index does appear to be more tailored to the circumstances of this development, the draft final order uses that Mortenson Construction Index in the early years. In 2020, the parties stipulated to a 5% inflation rate, so that is easy to resolve. in the subsequent years to reflect Mr. Grant's testimony that an aero unit applying their inflation rates is a reasonable proxy. The draft final order also uses CBC's proposed Treasury break-even rates for those later years of the project. So in sum, the avoided cost of capacity is based on an aero unit applying CBC's inflation rates, but using the hybrid capacity contribution developed through ELCC to calculate the total payment. Moving on then to ancillary services. Under this particular issue, CBC, through its rebuttal testimony of Mr. Grant, acknowledged a certain degree of responsibility, I'll say, for schedules 3, 5, and 6 of Northwestern's open access transmission tariff, or OAT tariff. It's a FERC regulated transmission tariff. In recognition of CBC's acknowledgement, this draft final order makes CBC liable for those 3 schedules until such time that they can demonstrate that they will be able to self-supply those services through their battery resource. The draft final order does not, however, make CBC responsible for the Schedule 11, which is a, sorry, one moment. Yeah, it does not make CBC responsible for Schedule 11 on the grounds that the proposed contract language would include a variability charge, which would, in essence, charge CBC for all of the fees, costs, penalties that may be involved if CBC is unable to deliver a firm energy per the schedule that they will be providing Northwestern. And Schedule 11 is designed specifically for wind resources that are unable to schedule. At best, you can forecast the wind resource and all the energy that may come in through that wind resource will simply be dumped into the system. And so there needs to be a regulating resource available to match the increases and drop off of that wind resource. Because CBC represents that it will be able to regulate itself through its own battery, the draft final order does not charge Schedule 11 and instead makes them liable should they fall short of their commitment to self-supply that sort of regulation. I should note at this point that there is 2 changes, one that I skipped over before and one change that will apply to the ancillary services. So if you'll bear with me, I'll go back one step here to the avoided cost of capacity and the inflation rates. The disposition of this inflation rate issue is different in the staff memorandum dated June 13th that describes the rationale for adopting CBC's proposed long-term inflation rates. And those were the Treasury break-even rates, as opposed to the Treasury target rate that Northwestern advanced. So it's important to note that this is different than, this is a fundamentally different disposition of the issue of inflation rates than what was proposed in the draft order. That staff memorandum from June 13th provides the reasoning why. And if any commissioner has any questions, I would of course be happy to discuss that further. The second change is to the ancillary services section, and that is discussed in the last, let's see here, the bottom of page 2 into page 3 of the June 13th staff memorandum. And that discusses the fact that there is no current variability charge in any version of the contract that keeps dispatch control of the battery with CBC. And so because we are leaving dispatch, or because the proposal here is to leave dispatch control with CBC, the contract will need to be revised to incorporate that variability charge in lieu of Schedule 11 services. So that additional language in the June 13th memo provides that the parties will have the ability to negotiate the particular language, provided that it gives Northwestern the sort of assurance that the commission would believe is necessary to rely on that scheduling that CBC would be providing through its battery. Moving on then to issue number 7, that is the network upgrade costs. This is an issue that was previously decided in the last CBC case when the commission assigned the full cost of any network upgrades to the CBC projects. CBC in testimony and in both pre-filed testimony and live testimony during the hearing acknowledged that responsibility and argued that this issue was resolved. So the final order, draft final order here proposes to leave that issue resolved. The two prior projects would pay for the network upgrades unless for some reason they don't proceed. And these two projects do proceed, then these projects will become liable for the same network upgrades, applying the same theory and reasoning the commission used in the last CBC order. There were a number of disputed contract terms, and this is issue number 8 of the draft final order, that did not affect the calculation of the avoided costs, but are nonetheless important for the commission to resolve. They concern primarily legal issues that did not receive a lot of fact development during the hearing. So those are discussed in the draft final order, and I'll leave the draft final order to speak for itself at this point. Final issue is the LGIA suspension. This is a request from CBC to order Northwestern Energy to to continue the suspension of the large generator interconnection agreement with Chafin, the parent company of Caitlin's Beaver Creek. This is a discretionary question for the commission. The draft final order does not exercise authority to order Northwestern to extend that LGIA. That, I believe, Mr. President and Commissioners, covers the entirety of the issues that are resolved in the draft final order. So at this point, I'll stop talking and stand for any questions that the commission may have.
Thank you, Mr. Hamilton. Vice President Johnson.
Thank you, Mr. President. Mr. President, just very briefly, you know, these dockets have become increasingly complex over time. And I just want to say that after extensive review and discussion with staff, it is abundantly clear to me that staff approached this with both thoroughness and competency, and I appreciate the work that legal and regulatory have done on this to bring us what I think is an excellent proposed final order. So, Mr. Chairman, I would move that the commission approve this proposed final order as amended by staff's recommendation as the final order of this commission, and that we authorize staff to make further edits to improve clarity and accuracy without changing the disposition of the issues, Mr. President.
I will second that motion. So we have a motion and second. I would just relate to Commissioners Fielder and O'Donnell that my screen is now completely black, so I can't tell if you're raising your hand. So just feel free to jump in, as I can't tell if you would like to speak. Discussion on the motion.
Mr. President,
Mr. Fielder.
I'd just like to concur with the Vice President's comments. I really appreciate the work that's gone into this, the clarity that's come out of it, and I will support the motion. Thank you.
Thank you, Commissioner Fielder. Commissioner O'Donnell.
No comments other than to echo the previous two commissioners. Great job. And I find it to be somewhat curious that Mr. Hamilton, after that long exposition, would think that there would be any questions left over afterwards, because the clarity was very, very good. I really appreciate the effort that staff, in particular, Mr. Hamilton, put into this. Thank you, Mr. Chairman.
Thank you, Commissioner O'Donnell. All right, I would echo the sentiment that was offered by Vice President Johnson. I would also relate that this proposed draft final order is the product of deep consideration by regulatory and legal staff, as well as by commissioners. We had multiple meetings to talk through the issues. And I also agree that the product that is being presented today is an excellent product and represents a fine product for a final order of this commission. Therefore, I will support it. Additional discussion? Seeing none. All those in favor of Vice President Johnson's motion to approve the draft final order as amended by staff's recommendation as the final order of the commission signify by saying aye.
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 Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Hamilton. Tremendous work. Thank you. Okay, the next portion of the business meeting will be a closed session. This will be a litigation status update, which is commission initiated. We will be going into closed session to discuss updates on pending litigation and discuss litigation strategy for the agency. So this will be closed to the public. At this point in time, I would note that the presiding officer of any meeting may close the meeting during the time discussion relates to a matter of litigation and or litigation strategy. And the presiding officer, which is me in this case, determines the need to protect agency litigation decision-making and the discussion exceeds the merits of public disclosure. I have determined that the discussion in this closed session will involve discussions and decision-making related to ongoing litigation in which the agency is involved as a party. And I believe that the interests of privacy outweigh merits of public disclosure. As accordingly, as the presiding officer of this meeting, I am closing this meeting to the public. And I would say upon resolution or conclusion of the litigation status update, today's business meeting will be adjourned. Before we go into closed session, I will announce that the next PSC meeting will be June 28th, 2022. We will not be having a business meeting next Tuesday. All right, let's move into closed session. Thank you.